that.
So another week, another round of legal challenges to President Trump's busy agenda, from DOJ efforts to deportations. Democrats are making full use of the only leverage they really seem to have to try to slow down the president, which is the courts. How quickly will some of these cases go all the way to the U.S. Supreme Court? Well, let's bring in our legal panel. Ilya Shapiro, Manhattan Institute Senior Fellow and Director of Constitutional Studies, and Tom Dupree, former Principal Deputy Assistant U.S. Attorney General during the George W. Bush administration. Great to have you back with us. Okay, so let's talk about this idea of these nationwide injunctions. You've got hundreds of federal district court judges, and any one of them right now can put all kinds of things on hold. A number of the justices have expressed concern about this. Something from Justice Thomas in a 2018 decision, a concurrence, he said, "I'm skeptical the district courts have the authority to enter universal injunctions if their popularity continues. This court must address their legality." A 2020 concurrence from Justice Gorsuch said, "By their nature, these injunctions tend to force judges into making rushed, high-stakes, low-information decisions. A single loss and the policy goes on ice, possibly for good." Ilya, will they rule? Is it time? Have they gotten to this conversation now?
What's up, everyone? Today, we're diving into the explosive clash between Chief Justice John Roberts and President Trump that has the entire legal world buzzing. The Supreme Court's top judge just publicly called out Trump over his impeachment threats against federal judges. And trust me, this power struggle has massive implications for how our government actually functions. Roberts dropped a bombshell statement saying impeachment is not an appropriate response to disagreement concerning a judicial decision. Bold words from a typically reserved Chief Justice. But here's what makes this truly fascinating. This fight isn't just about Trump. It's about a fundamental power struggle that's been brewing for years between the courts and the executive branch. Let's break down what's really happening behind the scenes and why this matters way more than most people realize.
Now,
It's more than time for the Supreme Court to give guidance, not just putting an end to it necessarily. In certain cases, you can imagine you only want one policy for the whole government. Let's say a restriction on travel. You can't have different rules for customs in JFK Airport versus LAX. But the appeals have to be accelerated. The Supreme Court might need to step in. And at the end of the day, I like the idea of having a three-judge panel. This wouldn't require new legislation from Congress, but if you're challenging a nationwide program, there should be more than one judge involved.
well, and it's not just those two justices who've spoken about it. Here's Justice Kagan back in 2022.
You look at something like that and you think, that can't be right. In the Trump years, people used to go to the Northern District of California. And in the Biden years, they go to Texas. And it just can't be right that one district judge can stop a nationwide policy in its tracks.
Yeah, and she said, and leave it stopped for years that it takes to go through this normal process. It turns into this forum shopping exercise.
That's exactly it, Shannon. And look, I don't say this often, but Justice Kagan is exactly right here. And that she does.
Tom Dupree, Justice
Absolutely.
Kagan
I'm
is
going
exactly
on the
right.
record. She nailed it, Shannon. Because here's the thing, is that what we have seen, and we're seeing right now, is the liberal playbook is you basically want to stop a Trump policy cold. What you do is you search around to find the judicial district and possibly even the judge that you can shop for who is likeliest to issue that nationwide injunction. I don't think that's a good thing for our legal system. And that's why I do think it makes sense to at least consider possible different approaches where you would get a small group of judges, a panel of judges, to make what is a hugely momentous decision.
Well, through all of this, there's been a lot of frustration, and some of the president's supporters have said, and the president, maybe we need to impeach some of these judges. So the Chief Justice of the Supreme Court, John Roberts, said this Monday, for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. Tom, he doesn't often say things like this publicly.
He does not. And look, that language he used, that it is not appropriate for Chief Justice, mild-mannered Chief Justice Roberts, that is like an expression of fury.
It's like tweeting in all caps.
It is.
Right.
It's his all caps version saying it's not appropriate. And look, I think politically, impeachment is just a super, super heavy lift, right? You would have to get to 2/3 of the Senate. That's never going to happen in this context. I think the right approach is actually the one that President Trump himself said in that interview clip you played, is that if you don't like a judicial decision, I think it's perfectly fair to criticize the substance of that decision. Judges are fair game for criticizing their decisions, and then you appeal it to the higher courts. You go to the Court of Appeals, and if necessary, to the Supreme Court of the United States. That's the best route, not impeachment.
Okay, so Sean Davis, who's the co-founder and CEO of The Federalist, said this on X in responding to Chief Justice Roberts. He said, had Roberts done his job and restrained inferior judges from overstepping their bounds and claiming for themselves authority and power which does not belong to them, he would not find himself in this predicament. What do you make of that, Ilya?
I think that's generally right. The Supreme Court needs to rein in some of these temporary restraining orders, TROs, which are, you talk about regular process. TROs aren't supposed to be appealable in the first place. And yet we have TROs issued about spending billions of dollars and things like this. So Roberts had the opportunity a couple of times already. Some of these have gone to the court, and the court has not given further guidance to the lower court judges. So whether you agree with what Roberts said or not, I think in terms of actually affecting the process, I think if he had a firmer rein, then indeed there would be less of this kind of chaos and both sides questioning the legitimacy of the judiciary.
Okay, one of the hottest debates has been over the use of the Alien Enemies Act to deport people. Last weekend, there were these plane loads of Venezuelans who left. The administration said these are gang members. It was time for them to go. They went to the Salvadoran prison. But a legal filing for the attorneys for those deported Venezuelans says this: if the president can designate any group as enemy aliens under the act, and that designation is unreviewable, then there's no limit on who can be sent to a Salvadoran prison or any limit on how long they will remain there. Ilya.
Well, there are, as we've learned from the Mahmoud Khalil case and other people being arrested for engaging in various protests that violate the immigration rules about who can stay, what qualifies you or disqualifies you for a visa. Same thing for gang members. If you're designated as a group that is against our national interests, the Alien Enemies Act is an old law. It's only been used during wartime, but the law is the law, and it states plainly what's going on. So there's been a lot of skirmishing over whether the plane was already in the air, had it departed our airspace, and what have you. But on the substance, I think the administration is within its powers, certainly with illegal aliens, but even with those on visas, to pull those if there's an administrative determination.
Yeah, Judge Boasberg says he's going to get to the bottom of those planes and when they left and hold people accountable. That's still being ironed out. But to this issue of whether or not everybody on that plane was a gang member, because there are family members who've come forward, as they would, to say they've been caught up wrongfully in this whole thing. But Wall Street Journal reports this. ICE officials say they vetted each Venezuelan, taking court records, interviews with suspected members, surveillance, and other evidence into account. Quote, ICE did not simply rely on social media posts, photographs of the alien displaying gang hand-related gestures or tattoos alone. That's from an acting immigration official. Where do we go from here, Tom?
Well, a few points, Shannon. Number one is I would say, look, there's no question that these people got more due process in the United States than they would have in probably almost any other country in the world. Second point is that I start with the text of the Constitution when you're talking about the president's powers. And when the president is acting under his commander-in-chief authority or his power to direct the United States foreign relations, he is at the peak of his powers. Does that mean that judges have zero role to play? Maybe not. It's possible. You could say judges must review the threshold decision as to whether there's been a predatory incursion and whether he properly invoked his powers, but there's no question that the president has a strong hand to play here. He is acting within very broad authority conferred by Congress under the Alien Enemies Act.
Okay, so quickly, we have several rulings that deal with probationary employees or people who've been fired, bringing them back or stopping the firings. It seems to me there's some language in some of these rulings that says maybe Doge and Elon Musk can't do it, but maybe the agency heads or the president more directly can do this?
I think that's right. You can do it at some point in some way. So the only question here is whether administration lawyers have crossed the T's and dotted the I's. There's no law in the book saying once employees are hired, you can't get rid of them unless they commit some sort of malfeasance. You can have reduction in force and layoffs and all of these sorts of things. So I'm confident that sooner or later this will all get sorted out, whether it's Elon, whether it's Trump, whether it's Trump directing one of Elon's colleagues or what have you.
Quick final word, Tom.
I think ultimately the president is going to be very successful in reducing the size of the federal government. Whether or not they have to do a do-over as to particular employees that were fired and say the president has to do it, not Elon Musk, maybe. But the president is ultimately going to get where he wants to go with the reduction in force.
All right.
The real issue driving this conflict is something called nationwide injunctions, a legal move that gives a single federal judge the power to completely shut down presidential policies across the entire country. Think about that for a second. One judge out of hundreds can effectively veto the president's agenda with the stroke of a pen. During the Trump years, liberal groups would rush to friendly courts in California. Under Biden, conservatives flocked to Texas. It's judicial shopping at its finest, and both sides have played this game. Even liberal Justice Elena Kagan admitted this can't be right, saying, In the Trump years, people used to go to the Northern District of California, and in the Biden years, they go to Texas. When justices from both sides of the ideological spectrum see a problem, it's serious. Justice Thomas called these injunctions questionable back in 2018, and Gorsuch warned they force rushed, high-stakes, low-information decisions. The Supreme Court knows this is a mess, but hasn't stepped in to fix it yet. President Trump's aggressive border policies have become the main battleground for this judicial tug-of-war. The administration recently deported planeloads of Venezuelans to El Salvador, claiming they were dangerous gang members who threatened national security. Trump's team invoked the Alien Enemies Act, a rarely used law that gives the president extraordinary powers during times of conflict. ICE officials insist they thoroughly vetted each deportee using court records, interviews, and surveillance evidence, not just tattoos or social media pictures. But the legal experts I've consulted make a compelling case for presidential authority here. When the president acts under his commander-in-chief powers, especially on issues involving foreign relations, he's operating at the peak of his constitutional authority. This creates a direct collision course between presidential power and judicial oversight that's now headed straight for the Supreme Court. Another fascinating angle in this judicial battle involves Elon Musk and Trump's Department of Government Efficiency, DOGE. They've been aggressively cutting the federal workforce, but several courts have blocked these firings. Here's where it gets interesting, though. The courts aren't necessarily saying the administration can't fire these employees. They're saying the process matters. The ruling suggests that while DOGE and Musk might lack direct firing authority, agency heads or the president himself could potentially make these same personnel changes legally. As legal expert Tom Dupree noted, the president is ultimately going to get where he wants to go with the reduction in force. The courts aren't stopping the agenda, they're policing the procedure. Before I get to my final thoughts on this clash, if you're finding this analysis valuable, smash that subscribe button right now. I break down the most important political and legal battles happening in America without the usual media spin, and I guarantee you won't get this level of straight talk anywhere else. This standoff between Roberts and Trump is forcing a long overdue conversation about reforming our judicial system. The legal experts appearing on Fox News proposed requiring 3-judge panels for challenges to nationwide programs instead of giving this enormous power to individual judges. This makes perfect sense. If you're going to halt a major presidential policy affecting the entire country, shouldn't that decision require more than one judge's opinion? The current system practically guarantees inconsistent rulings and encourages politically motivated forum shopping. Congress could fix this problem. The Supreme Court could clarify the rules. But neither has acted decisively, leaving us with this constitutional mess that undermines public confidence in both the courts and the presidency. Here's the bottom line. This Roberts-Trump conflict represents a critical inflection point in American governance. The Chief Justice is desperately trying to protect the legitimacy of the judicial branch while Trump is fighting to preserve executive authority from what his supporters see as judicial overreach. Both have valid points. Roberts is right that impeaching judges over disagreements with their rulings would destroy judicial independence. But Trump's frustration with single judges repeatedly blocking national policies isn't without merit. What we're witnessing is the painful evolution of a constitutional system struggling to address modern governance challenges. The founders never envisioned nationwide injunctions or the current scale of executive power. The ultimate resolution will shape presidential authority and judicial oversight for generations to come. And whether you support Trump or oppose him, everyone should want clearer rules about when and how the courts can check presidential power. That's all for today's deep dive. If you found this analysis helpful, you know what to do. Hit like, share with someone who needs to understand what's really happening, and I'll see you in the next video.